Gary Saul, welcome to Dash's Breaking Ground podcast. I did not, you and I rubbed elbows, I don't know, a couple decades ago. I guess
Yeah,
it's related, and your partner in crime, Matt. Um, uh, but it's really interesting. I did not realize how big your firm, Greenberg Traurig, has become. I understand it's one of the top 10 law firms in the United States. Is that about right?
yeah. I mean, back when I started, uh, our goal, I started in 1984 at Greenberg. The goal was to be 90 lawyers by 1990. Uh, we are now at about 2,700, with 42 locations throughout the States, throughout Europe, throughout Asia, throughout the Middle East. So, done a lot of growing. I'd like to say I'm responsible for it, but I'm absolutely positively not. Uh, Nothing to do with it. Stay here in
What
Miami
a
and
false,
try to
what a
mind my business.
false modesty. Yeah, a lot to do with it. I want to put it on the record for my audience to know that first and foremost, you are a nationally recognized lawyer in the real estate field, and from structuring to the new developments, ownership, financing of real estate projects, including I don't know dozens, hundreds of high-profile luxury, mixed-use, commercial, retail, hospitality, and residential condominiums all over the place. So actually, somebody mentioned, maybe it was Matt the other day, that you guys at Greenberg Traurig, and you as the point, probably over 85% of the residential real estate projects in the state. Is that when I look at your resume, it looks like it. But
Look, we're a little competitive, so we would like every high-end project in the state. We've got a real fair share of them. Let's put it that way. We want them all, and we've got a very good portion of them with a good cross section of developers and wandering all throughout the state.
yeah, no, it's a brilliant run that Greenberg has had, and you specifically, and Matt. Um, your name is. I could drop your name to just about anybody in the real estate business down here, and they know exactly who you are. They've worked with you, which is quite a testament to your expertise and experience, and on and on. Let me pivot a little bit because a lot of people are going to be very interested to hear your take on a handful of different topics. Let's start with what do you see as the one of the greater, or few greater challenges today that selling luxury properties are, and how you help developers navigate into this kind of challenging time.
Well, it's you know, there's a handful of issues that are there, but what our developers are doing are coming up with world-class designs and world-class use propositions. So it's making it easier. But Miami is growing; it's growing exponentially, and it doesn't come without its own growing pains. So to some extent, drawing the distinctions with which obviously a lot of the brokers will do between the projects, between the neighborhoods, and everything else is part of the proposition. We also have the realistic effects of climate issues that are affecting us. The insurance industry has not been our friend. And interest rates obviously have not been our friend as well. Having said that, the resiliency of the city and what's going on down here has been able to overcome a lot of those issues.
Um, what would you say today are the key legal considerations for structuring deals, especially with high-end luxury properties?
You want to try to make sure that you can deliver the product. I mean, it sounds so simple. And remember, I started on a project years before it comes to life. Okay. So we've got to look at it on the front side and go to market. The life cycle of a building is design, test, market test, see if there's interest in it, right? It's getting those pre-sales is what triggers the ability to finance the project and put it to life. So by the time a building comes to life, it could have been 3, 5 years from inception, especially on some of the larger mixed use projects. It could be much longer than that. So it's really a function of partly seeing into the future, but trying to maintain the control. More and more, we're talking about things like branded projects, right? And there's a ton of them in town, and they're great. But all the hospitality brands have entered into the market. Uh, but I've got to make sure that the hospitality brands can run the buildings consistent with their brand.
Mm.
So I've got to take the vision that the clients come up with and make sure that I don't get sideways with the Condo Act, which seems to, empower unit owners, empower the association. It's not a Ritz Carlton if the board is making every decision, right? That's every other condo. So we have a lot of that conflict that goes on that we've got to try to structure around.
Yeah, that's a really, really big deal down here where all these signature brands are now kind of enhancing their brand by connecting condominiums to them. So when you counsel your developers, you're talking not just to them in terms of their protection, but also then engaging with all the legal concerns that that flag may have, um,
Correct.
and how that enmeshes to make some sense. And so how do you do that? Actually, the laws do change. If you start on day one and offer up legal opinions on a whole host of sensitive topics, and fast forward 5 6 years later when the project's delivered, let's say, and let's say a few critical components in the law have changed, how does that work? Are you updating the agreements along the way through that period of time until the developer turns the building over to the association?
Uh, Combination of yes and no. So, look, the upside is because I'm in this business, I'm now in a position where helping developers is my full-time job. I used to do transactional work, used to do loans, acquisitions. I'm not. I'm simply doing condo plans, dealing with buyers, dealing with construction issues, and trying to get there. So we stay on top of the law all the time, and everything that we've learned from any other prior deal goes into the next document. So the document evolves daily. If I look at things we've done 6 months ago, the things we're doing today are different,
Really?
okay, in a lot of different ways. But with respect to your issue, the legislature meets a couple times a year and we'll change the law. Court cases can come out whenever they want. We live in a dangerous world in condos because buyers have rescission rights. Okay, when in Florida, if you buy a condo, you've got a 15-day rescission right on the front side of the project to cancel for any reason whatsoever. But if I make a change midstream, I give you notice of the change, and you've got another 15 days, but only if that change is material and adverse.
Can you define material versus cosmetic, or what defines a material?
Thankfully, not. To a developer, nothing's material and adverse. Okay, so buyers can never get out.
Yeah, that,
No, the court cases will look at the at whether or not it would affect the buyer's purchasing decision. In my experience, a buyer either wants to get out or he doesn't want to get out. And when the market's turning down, when he thinks he overpaid, they're going to tell me everything is material and adverse. Okay. If the market's good, nothing's material and adverse. But we try to focus when you're looking at it objectively. You want to look at the types of things that the buyer did think about. Certainly, they care about their unit, right? So if something physically has to change with the size of their unit, you worry about it. Now, if a shear wall got thicker by 3 4 inches, yes, it changed the square footage, and nowadays people pay a lot of money for
sure.
per square foot, but the functionality, the utility of the unit really hasn't changed even slightly, right? Because a lot of times people will say, well, what's a de minimis,
Yeah,
change? Is there a de minimis safe harbor? And the answer is no, right? If I dropped a 1 by 1 column in the middle of your master bedroom
yeah.
and there's no longer a place to put a bed, that 1 by 1 square feet is significant as opposed to losing a couple inches on a back wall. It's probably not. But they care about their units. They care about the budgets. Okay. They want to know what their maintenance fees are. And they do change. And the mere fact of putting together a budget, right now I'm putting projects in the market where I'm contemplating a 2028, 2029 delivery, okay, on larger projects. I don't know what costs are going to be 5 6 years ago. We have our budget estimators doing it, and we hire the best, and we do research, and we try to anticipate inflationary rates. But you go out, so there is a chance to miss it. Now, the state gives you some comfort there, and provides that changes, provided your estimates were good in the first place, changes beyond your control are not material and adverse. So we have some help, but obviously that's a sensitive spot for a buyer.
You bet.
If their maintenance fee is going to change dramatically, a buyer cares.
How would you
Then you get,
how would you define on the HOA fees? Let's say today you imagined and your crew put together a projection that said, just to use a round number, $2 a foot. And
yeah.
fast forward 5, 6 years, and it's looking closer to 275 or $3 a foot. Just to make the point,
If
how significant that's a real number for a 3,000 square foot unit, let's say, to a buyer. At what level does, or is this all negotiation with?
Well, no, look, so ultimately, if you get down to it, it's the courts. I do have some insulation where those cost changes are beyond my control. So things like insurance, things like your utilities, which is accounting for a lot of it.
Right.
Reserves is accounting for a lot of the change as well right now because of some law changes.
Yes.
So, those come into it, but I do have exceptions. Those items get carved out. The other time we have radical changes, because insurance is a regulated industry. So if insurance rates went up, the law gives me some protection. The utility rates are regulated. I have some protection. The reserves go straight to the buyer. It's not coming to anyone else. It's their money. They can go do it. I think to some extent we may see as reserves become more significant, um, that buyers will, as they're selling units, have the buyer buy out the previous owner's reserve account,
Mm.
which would make some sense. If I funded a reserve for a roof for 5 years, maybe you ought to buy it out when you buy my unit. But for the budget changes are always very sensitive, but because so much of it is out of the developer's control, we usually have some insulation for it. Doesn't mean I'm not going to be in a fight.
Okay. Understood.
But you would look at the buyer, you would look at, the price point and decide whether or not that change, it would reasonably change their purchase decision. For a lot, it would not. Obviously, it gets much more sensitive at the lower end.
Sure.
Okay. The lower end, that person can no longer afford the unit and they would definitely not have bought there.
Do you
So
counsel,
issues like that become
do you
sensitive.
counsel your clients to say on the lower end? I'm not even sure what the lower end is in South Florida because it's pretty high.
Yeah.
But so, do you counsel your clients if it's a if some buyer is really making a real issue of it, because whether they can't afford it or they're not interested or they see an opportunity to get out of the contract, um, how do you talk reasonably to a client to let that individual get out because it might create a firestorm and in terms of the uh, demonstrative change on the HOA fee or something on something else? Do you suggest? Do you work with your clients to say, look, guys, this is probably one we should give back, or let him out of the contract? I know it's
And so every developer's got their own threshold, but and a lot of times you can't let anyone out because of your construction loan,
yes,
right? Your lender's got to approve it. But you would typically, once you send out the change, the buyers have 15 days to react. So when you get that first letter, the first thing you want to do is be patient
yeah,
and see how many total people are looking to get out based on that issue.
oh,
Okay. If it's one, it may be easier to deal with. If it's 20, it's a different story, and you're going to have to take perhaps a different posture. Then you second would look at what they buy it at, right? A lot of our developers will go out with sort of momentum pricing.
yeah,
There's a first wave of people who probably paid a lower price than the second wave of people. Okay. If it's one of those guys who bought in really cheap in the beginning of the project, I might be happy to take that unit out because I now have tremendous confidence. So even though I'm 100% sure that that change is not material and adverse, happy to get that unit back.
sure.
I could probably make a 20% premium on it.
Mm,
So if he blinks and he even suggests that he wants to write out, I may go grab it.
mm,
But you are going to look at the world of people complaining first. So you've got to be patient, sit through the 15 days, see who comes at you. Evaluate those contracts in particular as to how you feel about them. Reconcile it with where you are with your lender and your lender requirements as to how many contracts you have, and then go for the fight. Always in this business, you're worried about the impact on everything else and everybody else, right? So I'd rather not start a war on the front side with any buyer. I don't need the publicity. It's not the kind of publicity any of our projects are looking for. You want to try to, take the temperature down
yeah.
as soon as you can. there are ways to work with a buyer, right? If the buyer thinks he has a right to get out, we don't. We could talk to them about maybe while we think you're still obligated under the contract, maybe we'll put it in with our inventory, see if I can get someone to take it off my hands. If I find a buyer who will take it off my hands, then I'm happy to let you out and buy yourself a little bit of time. So there's a handful of ways to approach it
Mm.
where you can soften the impact of the blow. But the first thing you've got to do with the client is make them be honest. Is let's look at the change and see if it's material and adverse.
So
Okay.
that's a really, really good point, Gary. And our audience are all or most are licensed residential. All of them are licensed real estate agents, and most of them do work in pre and new construction. So this is a really important point. I wanted to change the topic a little bit. Florida is rather unique in so many ways, but for on this on this very specific question, we're permitted. Developers are permitted to have progress payment programs with their buyers, meaning um, on the contract signing, it's X%, and then certain benchmarks, milestones are reached when the developer is permitted to ask for additional percent of the purchase price. Can you explain that to the audience? We are unique, and I'm not even sure what other states kind of permit this kind of payment, and the benefits obviously to developers as well. Can you explain that, the
If
process?
if this were a depot, Len, I'd answer the very specific question you answered, which would be benign and says in Florida you can ask a buyer to pay as much or as little as he wants at whatever stage he wants, and whatever the market will bear is lawful. I think the question you were going for is we tend to structure contracts with progress payments in part because we have the right to use those payments towards construction.
Correct.
If that was the
All
subject,
right, that is exactly the subject because it is so unique in the 50 states. As a matter of fact, maybe you probably know what other states.
not very many. And when lawyers from other states call and say, "You plan to do what?" I'm like, "Yeah, huh, that's what's going to happen." I would never let my clients, let me explain what it is we're allowed to do
Is
down here. Okay. In pre construction, okay, the state breaks deposits into deposits up to 10% of the purchase price and deposits in excess of 10% of the purchase price. There is no limit on how much I can ask for and when. I really can ask a buyer to give a 100% deposit on day one. Don't think they would,
mm,
but I certainly have the right to ask them. But what the state says is, as to those first 10% deposits, they must stay in escrow unless we post with the state what they call alternative assurances. And that's a bond or a letter of credit.
okay.
So if a buyer gave me a 10% deposit, if I wanted to get a bond or a letter of credit, I would file it with the state. Once the state approves it, I could take that 10% out of escrow. I can only take out up to the amount of the bond or the letter of credit. So that buyer's money is essentially collateralized,
Okay.
right? If the buyer's entitled to the money back and developer doesn't have it to give it back to him because he's spent it, you've taken it out of escrow and he's spent it, then the escrow agent would call on the bond to get the 10% to return to the buyer. So that first 10% is supposed to stay in escrow unless they get a bond or a letter of credit, and it's got to be approved by the state, and they can only pull up to the amount of the bond. So first 10% is relatively safe, but the money's not in escrow. Okay. As to deposits in excess of 10%, okay, so it's routine to get 20% at contract nowadays, probably another 10 or 15 at groundbreaking. And then maybe, depending how big the building is, sometimes at the buyer's floor, sometimes at top off, but we'll tend to get somewhere between 30 and 50%. Okay. So as to the portions which are in excess of 10%, what the law says is that once construction of the building has begun, we can take money out of that excess 10% account for use for construction and development of the condo. And there's a definition of construction and development. It's clearly hard costs, and it's a limited subset of soft costs. So architects, engineers, permits, the types of dollars that when they're spent actually enhance the project that I sold to the buyer. But what that means is that so typically I'll get 20% of contract, but I haven't started construction.
Right.
So that 20% is sitting there. Because one of the preconditions to be able to access the excess 10 is that I've commenced construction. Now I commence construction, that portion of the deposit that's in excess of 10% is available to be withdrawn from escrow. And almost every developer does it. I can't think of any that really don't.
Mm-hmm.
And in fact, the construction lenders want that. The construction lenders, when they're evaluating a project, when a construction lender looks at a project, they are looking at, is there sufficient money to complete the project, right? So between the money that the equity the developers put into the project,
Yep.
and the amount the lender's loaning and the usable deposits, okay, that should be able to complete the building plus a little bit of comfort, okay? So they're counting on those deposits and our use of those deposits as part of the construction funds to go forward. So yes, it is routine down here. We're going to get 30 to 50%. The buyer's going to have everything over 10%, probably in the ground at the time he closes.
And the developer obviously uses anything above the 10%, as you say, for all these hard costs. So that reduces, with some degree of significance, the amount of money then that the developer needs to go to the lending institution. And
correct. It reduces the borrowing cost.
Right.
There's no question about it.
And you have those in your contract. So if I come and buy a project tomorrow that is part of this, program, this protocol, you're going to tell me as a buyer, okay, Mr. Buyer, this is what our deal is, 20%, and then 10% at breaking ground, and 20%, whatever it is.
Yeah.
I know that up front, so there's no surprise.
Correct.
That. But you say, is there the ability for a developer, should the circumstance arrive in year 3 or 4 of a 6-year build out, that they need to ask for more money? Are they, if it's not in the original contract, can they?
It's a contract. It's a contract. I can, but you don't have to give it to me, and I have no right to demand it from you.
Got it. When projects now, and it's hard to, they all seem to be very, very large to me, as compared to maybe 10 years ago plus. What is the law as far as when the developer has to deliver the project? How are they forecasting that now, and what are the legal rights of the buyer and what the developer must do? How is that stated in the contract?
So way back when, Len, when you and I started, okay, there was a federal law we had to worry about as well. Right now, I've got a set of regulations I have to comply with in Florida, which is my Florida Condominium Act. But we used to have the Interstate Land Sales Act.
Yes.
And that was federal registration law, and it was really designed to protect you from getting stuck buying swampland.
Okay.
Right? It's a land sales law, not so much a condo, but it was interpreted back then to affect condos. So most developers didn't want to comply with it. It had a complicated, not complicated. It had an annoying filing process that was irrelevant, right? It would, again, picturing swampland, I'd have to complete a registration that would say, where's the nearest street? Where's the nearest utilities, right? When you're buying on Brickell, you kind of see the street right there, okay? Different than if I'm selling you marshland up in the state where it's not connected to a roadway system and it's not connected to a utility system. So where's the nearest school? Where's the nearest shopping? Where's the nearest bus line? I'd answer all this foolishness that was mostly irrelevant, okay? But back then, we would want to find an exemption from registration if we could. Okay. And the only one that really was available for us, there was one for, there's one for de minimis projects under 100 units. And there was another one for, it was called the completed lot exemption.
Okay.
And the completed lot exemption means I'm either selling something that currently exists or where I'm willing to unconditionally agree to complete construction within 2 years from the date the buyer signs the contract.
I remember that.
So I used to have a 2-year bullet in every contract.
Right.
I'm going to complete within 2 years. And if I'm not, I'm a default. And the way interstate land sales was interpreted, they wanted that to be such a hard obligation that if I did, I couldn't, if I put the 2-year obligation in, I couldn't limit any remedies. If I don't meet in 2 years, bring the world upon me. I can't limit a single thing. You have every bit of recourse in the world. Okay. Um, Back when the market crashed, everyone was trying to get out of every contract, and there were a lot of them made on interstate land sales claims. And through that process, good news is we prevailed through most of them, notwithstanding those buyers still didn't close. We prevailed through most, but through that process, it became clear that the interstate land sales office really was doing nothing to protect a buyer of a condo in a municipality
Yeah.
like Miami. Um, but it was more of a nuisance, and it was being used and abused as perhaps a way not to be able to comply because it was hard to reconcile some of the terms. So an exemption was adopted to the interstate land sales, carving condos out. Long way of saying I no longer have any obligation to complete within 2 years.
Wasn't that then referred to as a HUD filing that most developers did? Wasn't that
Yeah, interstate land sales was administered by HUD back then.
correct?
So yeah, we would do the HUD filing. And now I'd try to avoid it with the 2-year exemption,
Sure.
or I would do the HUD filing. That's where I
Which
was.
permitted how much additional time to the understanding, or there was now if you go
I'm now out of my 2-year obligation. So I'm sort of where I am now. So where I am now is it's just a matter of contract. So I've got to put something. If I just say I can complete whenever I want, as a lawyer, I'm concerned that's an illusory obligation,
Yep.
right? If I can never be in default, it's 100 years from now, and I'm still saying, yeah, I'm going to get around to building your building, okay? That contract should not be enforceable,
So what do you
okay?
say now to your developers?
I will go ask them what their real life schedule is, and I will probably add anywhere from 6 to 18 months to that. But I will have a deadline for completion in my contract, and I am prepared to be in default if we can't meet that deadline. Granted, hopefully I've added enough fluff in there,
Yeah, yeah.
okay, where I've got some time to go ahead and complete. But if not, we're in default. Buyer comes after us for damages.
Are you seeing that, or have you seen that recently, or is that sort of not yet? The market really has not been in that, or most projects have not.
We're so far, no, I'm not seeing buyers get out. I'm not seeing them look at. We're generally not late. Okay, the last couple of years as we came out of the pandemic, um, the market's been on fire,
Yes.
which meant getting construction crews has been harder
Yeah.
than you'd want it to be. We've all faced delays to some extent. Hopefully, we've got enough fluff in our contracts to give it, but it does create the types of things that your clients, the brokers face all the time, right?
Yeah.
They'll ask the developer when you're going to finish. He says in 26, and then they look at the contract, and I've got him in late 27. And like, oh, wait a minute, I thought you told me 26. And I'm like, if everything goes right, it is
So
26.
that's exactly, you're really kind of transitioning to the next question. So again, lots of our audience are agents and brokerage firms and on and on and on. And
Right.
so how do you help the agents that, have made certain sales and, their clients are in their ear all the time? You give me an update on the construction. What are you thinking there? They have their own lives, they're planning, whatever. And now how do you help them deal with these? There may not be extended delays, but
Right.
they are delays. And everybody's now is really kind of raw. Everybody's kind of upset in the process, but the agents are on the front line. How do you
So
give them information, counsel on this stuff?
So there's a couple things, and while my contract has become more and more onerous over the years because of so many different things we've confronted, the engine of the business is sales, period.
Yep.
Okay? If there's no sales, we're never going to build the building. Okay? Which means I've got to be somewhat user friendly. I literally, right before this started, I got a call from the listing agent on a project that we're doing in Bay Harbor Islands, and I got to make this deal, and what am I going to do? And it's my job to help make the deals. I want to make them on behalf of the developer. Look, we need to be as transparent as we can.
Mm-hmm.
Okay, it's just very simple. I mean, I probably have the protections under my contract to do things, but I understand they can't sell that. Okay, so I've got to go ahead. I'm going to try to give them the facts. I'm going to tell them exactly what we're intending to do. I'm going to tell them why the language is there,
Mhm.
that provides an extra layer of protection. But the equities in these things, right? What I said before is we wouldn't build the buildings if it weren't for the buyers,
Correct.
right? But these developers, they got a lot to deal with between the time they get the permit and the time the building goes up. There's stuff. Okay, we all know what that stuff is, but it's in the ground, it's in the environment, it's in the politics, it's in everything, right? Everything impacts the ability to deliver.
Yep.
If the relationship was so fragile that the buyer can go away, then we couldn't do what we do. This pre-construction business would go away. So I just want to be honest with the buyers. I want to tell them what we can do. I want to tell them what we can't do. I've got some tricks and some help that I can give when there's legitimate concern. Okay, and I sold a couple buildings, and every buyer, while ridiculously wealthy, was in their 80s. It's just that kind of building, right?
Yeah.
And those guys didn't want to wait 5 years, okay, for the building. That may not make it vulnerable, right?
Yep.
Having said that, I can't sign contracts and say if I'm later than my perfect date,
Yep.
you can get out because again, lender won't let me lose a contract. I can't afford to lose the contract, but I can give them some flexibility. I can maybe let them assign the contract and get out,
No.
or maybe cap the ramifications to them if they go down. So there's ways to play with it and address
Mm.
the various issues that are there. Um,
Do you
but generally, I can only tell them the truth.
do you
Okay,
get
I can tell
involved?
tell the agent the
Yeah.
truth.
No. So, which is always a good policy. The agent may not want to hear it that way. Do you get involved, like hand to hand combat with buyer, let's say in the 15, 20, $25 million range, who has some real legitimate concerns, and maybe it's a older individual who is it may not survive when the building is delivered and has got real issues, generally not always, but sometimes the higher the purchase price, but these are not that buyer's first rodeo, as it were, and they can be litigious and they can be nasty and they can be very aggressive in terms of what they believe their rights are. Are you sometimes on the phone in these
Oh,
situations, or
all day long, all day long. Okay, so unlike we're a big law firm, and it's the real estate practice is considered commercial. I am doing residential sales. Don't get me wrong, I get $60 million units that we've been selling. So they're as big as a shopping center sale, but yes, we're doing them all the time, every day, from the most benign vanilla to obviously the bigger the units, the more high end these projects, the customization of the units is difficult, and everyone wants it, and that buyer is particular, and they want what they want. And the flip side is it's hard to give someone unilateral customization rights. If you want to adjust the ceiling because your lighting plan or your speaker system or whatever, but there's a unit on top of you or below you to the side of you, okay? So it's not as if I could just do it. Move the AC over here. Move that. I got a stack. I got a plumbing stack that's coming down. I appreciate you. The bathroom maybe would look great over there. I don't have a plumbing stack. So
uh,
in with some of these buyers, and obviously the brokers know this, me telling them no is something they've never heard in their entire life.
yeah.
Um, So it makes for some interesting conversations, there's no question at all. But yeah, a lot of what we do is help
So
facilitate
would you
those
say
sales.
that of 30% of your day is being kind of a pseudo therapist to everybody in the mix? Everybody's
It is
hair
because
on fire regarding this stuff. Yeah.
no, it really is because I've got it from so many different levels, right? I've got the CFO of the developer who's just simply looking at the economics of the deal. Okay. I've got the design side who's looking at the aesthetics. Okay. So, and I got to reconcile those guys. Then I got to be able to sell it, and the buyer perceives it as something different. And so, all day long, you've got to grab all those guys and make sure they're in sync. I know the world of what's happening in sales. I also know if I give a buyer one thing, somehow every buyer in the building is going to know about it. So I have to be judicious and say, if we're going to do this, are you prepared to do it for everybody? Where are we going? So it is a strange. You know what? It's for a lawyer. What I've learned is most lawyers handle tasks. I need a purchase agreement. I need a sale. Me, I'm raising a child. Okay, don't know what it's going to need. Almost all of my children are what I'll call special needs, some in the most wonderful ways, some in the non-wonderful way. But I don't know where my attention is going to be grabbed any particular day.
I love
And
that. They're all your children. They all have special needs, and you're absolutely right. Let me, I love that framing, Gary. So what we're seeing now in South Florida is, I don't know that it's a new business model, but a handful of projects we're beginning to see, no rental restriction. So
yep.
the developers are bringing this. It's not that it's new, but it certainly seems to be as a juxtaposition to hotel condominiums, um, uh, whereby you sell a unit. It's generally understood as investment. There's an on-site management company who will take a percent of the rental, and the balance goes to the buyer. How complicated are these deals to structure, and are you seeing yourself more and more of them?
To do the short-term rental
Yeah,
deals,
or no rental restrictions as we're seeing it.
so no rental restrictions are, they scare me a little bit. For me to do from a document standpoint, there's really two different buildings like that. Okay, one of them has a flag where the developer has someone there. They're trying to have a brand and deliver brand consistency throughout the project. And that's one type of short-term rental building. I've got others where the developer doesn't have a stake going forward and is content to let the building, its short-term rentals are available. Use whoever you want. Use Airbnb. We've got a lot of Airbnb friendly buildings down here. So let's go to those. Those don't give me the same level of legal concerns, but I am worried about the chaos, right? Because now every owner is their own entrepreneur.
Yep.
Everyone has their own standard, right?
Yes.
Some may have no standards. So I'm worried about the potential for a frat house. Okay. How do I know who's in the building? How do I know who's supposed to be in the building? Okay. Typical condo, I don't have the time to require prior approval of a lease that you'd have in a typical residential building. Because if people are coming in nightly or every 2 nights, there is no time for board meetings to approve them. So what we've tried to do is implement some rental restrictions so that we know who's coming in, try to set some quality standards. Usually in those buildings, we'll put some occupancy limits. I really don't want you smushing 12 people
Got it.
into, a studio. So we'll try to do it, but the enforcement is difficult, right? These managers are not equipped to be cops. Okay, they don't know. And if I'm happy to let my unit go for $85 a night, I'm going to attract an $85 a night crowd,
Sure.
and the guy next door who thought he was going to get 650 a night is not getting 650. So it is a little bit hard when you have a flag there. Okay,
Sure.
um, there's a whole different level of concern because they're going to want to leave if the chaos is too much.
Agreed.
And they're also going to leave if enough of the business doesn't flow to them. It doesn't help them to
Yeah,
do that.
that's interesting. So on these limited or no rental restrictions, it's if I'm a buyer, I guess I'm relying on, it sounds like, the developer to bring in a management company that will have certain standards and certain protocols. They behave in a certain way versus if I'm buying a unit for $1 million, and expecting a certain return that I've worked out with the selling agent, let's say, or certain hypotheticals, and all of a sudden this turns into an $85 a night uh, property. I'm wondering what that buyer's recourse might be. So I guess that's what you're talking about. That's your
Yeah, man. And so the stress is, look, everyone's, condo associations run by a democracy, right?
yeah.
And we've seen it in every building, right? That the typical condo building, even the most traditional residential building, you go for a couple of years where the board's job is to keep the budget flat, right? And then all of a sudden, everyone realized the building got run down. And then you need a guy who's going to restore the luster in the building, and things go up until they realize the costs are getting too high, and they revote back in the guy who will make sure. So you're going to have the same thing here. What is the bulk of the building? What does the bulk of the building want to do? Now, sometimes if I sell the unit expensive enough,
Mm,
you'd like to think no one would let it go to a lower standard,
correct.
right? So maybe the price point would do it. The flip side is that a lot of the projects are not the higher end projects, right? They're the lower end, not lower, nothing down here is lower end anymore,
Correct.
but relatively it's a lower end price point, and everyone wants to handle it. Everyone's got their own dreams as to how they're going to monetize that thing if they bought it as an investment. So it's hard. You will start with those rules, but even things I do can be amended, right? If I put some constraints in on the front side, if it gets run, and I can think of a couple of buildings like this where we're making things easier and a free for all became the rule, and the building got run into the ground. Okay. And the problem is that that's ultimately those types of decisions are going to be set by the owners and the board members. So it will be interesting to see them play out. We've done what we can on the front side to create some stability, some uniformity, try to establish some level of quality standard that has to be upheld. Um, but it's up to the owners to maintain those things. If they want to let them go, if they don't want to enforce the rules, then you create a bit of chaos.
Um, Very well said. We're beginning to see again, which is really good news, activity from South America, some Europeans, and some other markets as well. What are the concerns? So once upon a time, in the old days, that developers were concerned not being able to validate foreign buyers' assets and to determine if they were creditworthy or they were contract worthy, as it were. And they used
Right.
to ask for two or two and a half, three times the deposit to ensure that if something did go south, that they were more than covered. Is there still some of that, to the best of your knowledge, going on in terms of foreign buyers who are not able to proof of funds components, stuff like that?
Less so than in the old days. Okay. Nowadays, with OFAC, there's some listing of money that may or may not be seen as bad.
Mm-hmm.
There's FinCEN, there's been these targeting regulations that have affected Florida. Basically, when I have an LLC that's buying with all cash in Florida,
Yeah,
we've had to break it down to individuals, primary ownership, and report
I
that.
remember that.
So
Yes.
that's been the law probably for the last 3, 4 years. So as a result, we have a little bit more respectability for it,
Yeah,
and also the banking regulations have changed so much. Don't get me wrong. When I first started practicing, I would literally take home suitcases of cash from a closing. When I first started, I would have closings in person at Key Colony on Key Biscayne. Back then it was a very high end building, probably cost about $300,000, which was a ton way back when.
yep.
And I'd be coming home with 260 of it in a suitcase. I'd just assume someone's going to run me off the road on the way back to the office. But obviously now we can't accept cash, and almost all the money's running through banking regulations. And because of all the know your customer rules,
Yes.
even the outgoing bank, the incoming bank are checking it. So we're a little less
Which
concerned.
has helped our
Um,
legitimacy down here as far as transparency. That no one can, if I heard you correctly, no one from anywhere on the planet can buy a unit in Florida through an LLC and not identify an individual who's attached to that LLC. Is that correct?
correct. But I haven't seen the press pick up on that. And apparently we're still a place where people go to hide their money. Best I can. based on what I read, but not true at
but
all.
not true at all. So I wanted to pivot a little bit as we come to the end of the podcast, this episode. So it's said in life that it's not about what happens to you; it's about what how you respond to what's happened to you. So in your really fabulous career, can you share maybe something that might not have gone exactly according to plan, and you had to respond in a certain way, whether that's in terms of your work that illuminated you in such a way that it produced a better understanding of who you were and how you approached your job.
Uh, Len, I'd say my primary trait as a lawyer is fear and paranoia. Okay. I live every day knowing that there's a ton of stuff I don't know.
Uh,
Uh, and as a result, I spend a lot of time listening and learning from everyone. There's not a single, when I started here, um, I I went to the paralegals. What do you do? Why do you do what you do? Teach me how to do it. Okay. So the secret to all of this is to go ahead and learn every day, right? Pick up from all the smart people you could think of. I learned a ton from Matt. Okay. Going back to all the people, you and I dealt with. I learned a ton from Tom Daly. Okay. There's just a lot of guys who were so smart, way smarter than me. And the question is to ask to know that there's always more to know. There's always another side to see. Like you asked before, I have to understand what the brokers are doing. I have to understand what's happening in the sales center.
yeah,
Okay, I got to learn to be user friendly. But when the market turned down, right, this 2008,
yeah,
I probably had we probably had close to 20,000 contracts in the market at that
yeah,
time with projects that were under construction,
mm,
and it became relatively obvious that buyers weren't going to close, right? The values were driving. At that point, we only had 20% deposits.
yeah,
A lot of them were, okay, a HUD filing. One of the things with the HUD filings was we were capped at keeping 15%.
mm,
Okay. So I had a 20% deposit. I couldn't keep more than 15. Um, Market turned down every buyer. I would get hundreds of letters with buyers purporting to cancel and all saying they had a right to because I didn't do A, B, C, or
sure,
D in the filings. I mean, we were under attack by everybody. It was a cottage industry, and it's hard. It's hard to have confidence in anything you do.
mm,
Okay, because everything could be better, right? I come into it knowing everything can be better. There's something to be learned from it. So you're under attack all the time. You just got to get your defenses up. You've got to go back and justify that you did the best you could do under the circumstances. Now the reality is we prevailed under pretty much all of
you
them.
did.
Okay,
You did. It
but
was a really scary time, and the fact that we were able to kind of come out of that a lot wiser, smarter, a lot more
yes,
wisdom. Gary, look, it's no surprise, certainly to me, having known you and your work for decades now, and to my audience, that you're the most even keel, knowledgeable, smart, uh, good guy, and it's no surprise that you probably do 95% of the residential real estate in Florida because you've earned it. I can't thank you enough for your time. I want to wish you and your family
sure.
a great holiday and all of that. And I do appreciate your spending the afternoon with me on
Absolutely.
Thank you, Gary. Have a great
Good to catch up. Happy holidays to you.
thank you, buddy.
Thanks.
You bet.